Welcome to Chapter 11 of your UBC Real Estate Exam Prep, Contracts for Real Estate. In this chapter, we'll dive into the essential elements that make up a binding contract in real estate transactions. Understanding these components, such as offer, acceptance, and consideration, is crucial for successfully navigating real estate deals. We'll also cover the different types of contracts, what makes them legally enforceable, and the various clauses that could impact both buyers and sellers. By the end of this chapter, you'll have a solid understanding of how contracts are structured, how to manage risk, and the key legal principles you need to know to protect your clients and ensure smooth transactions.
Question 1. When the licensee receives a deposit in a typical real estate transaction, the licensee's brokerage holds it. Correct answer: D, as a stakeholder. Explanation: in a typical real estate transaction, the brokerage holds the deposit as a stakeholder, meaning the funds are held in trust and are not considered the property of either the buyer or seller until the contract conditions are satisfied or the transaction is otherwise concluded. This ensures neutrality and protects the interests of all parties involved. Other options. A, for the seller. Incorrect. The deposit is not immediately available to the seller but is held in trust. B, for the buyer. Incorrect. The deposit does not remain the buyer's property once handed to the brokerage. C, as agent for both. Incorrect. The brokerage acts as a neutral stakeholder, not an agent for either party regarding the deposit. Question 2. A contract respecting land or a disposition of land is not enforceable unless there is, in writing signed by the party to be charged or by his agent, both an indication that it has been made and a reasonable indication of the subject matter. The preceding is an extract from which statute? Correct answer: D, Law and Equity Act. Explanation: the quoted provision is from Section 59 of the Law and Equity Act in British Columbia. It requires that contracts or dispositions of land be in writing, signed by the party to be charged, and include a reasonable indication of the agreement's terms and subject matter. This statutory requirement helps prevent disputes and ensures clarity in agreements related to land. Other options. A, Real Estate Services Act. Incorrect. This statute governs the regulation of real estate licensees and their conduct, but does not address formal requirements for contracts concerning land. B, Statute of Frauds. Incorrect. While historically similar to the quoted provision, the Statute of Frauds has been replaced in British Columbia by the relevant section in the Law and Equity Act. C, Land Title Act. Incorrect. This act deals with land registration and the Torrens system of title registration in British Columbia, not the enforceability of contracts. Question 3. Section 52 of the Competition Act prohibits false or misleading advertising and creates an offense punishable by imprisonment or a fine. Which of the following statements is false concerning this offense? Correct answer: B. All false advertisements made to the public will constitute an offense under the provisions of the Competition Act, even if the misrepresentation is not misleading in a material respect. Explanation: this statement is false because for a representation to constitute an offense under Section 52 of the Competition Act, it must be false or misleading in a material respect. This means that the misrepresentation must be likely to influence a consumer's decision to buy or use the product or service. Not all false advertisements fall under this offense unless they meet the material respect criterion. Other options. A. This offense punishes misleading statements in various forms, including oral and written. True. The Competition Act covers all forms of representation, whether oral, written, or other communication methods. C. Both the general impression of the representation as well as its literal meaning are relevant in determining whether a breach of the act has taken place. True. Courts assess both the overall impression created by the ad and the precise words used. D. The person making the representation can escape liability if they can show that they honestly believed the statement was not false or misleading and exercised due diligence in making sure that was the case. True. This is a recognized defense under Section 52 of the Competition Act. Additional notes. The law aims to ensure honesty in advertising and prevent consumers from being misled by claims that are likely to influence their purchasing decisions. Question 4. Which of the following statements about false or misleading advertising as prohibited by Section 52 of the Competition Act is false? Answer: A. It is not an offense under the Competition Act for the visual advertisement to create a false impression as long as the written statements are true. Explanation: this statement is false because Section 52 of the Competition Act considers both the general impression created by an advertisement and its literal meaning when determining whether it is false or misleading. This includes visual elements, images, or any other communication aspects, not just written statements. If the overall impression is deceptive, even if specific written claims are technically true, it may still breach the Act. Other options. B. For a misrepresentation to be contrary to the Act, it must be false or misleading in a material respect. True. The misrepresentation must materially influence a consumer's decision to buy or use a product or service to be considered an offense. C. The Competition Act applies to both oral and written representations. True. Section 52 explicitly covers all forms of communication, including oral, written, and visual representations. D. To avoid liability under Section 52, the person accused of the offense must show that they honestly believed that the representation was not false or misleading and exercise due diligence in making sure that was the case. True. A defense under the Act includes proving due diligence and honest belief in the accuracy of the representation. Additional notes. This prohibition ensures that advertising practices are fair and do not mislead consumers through false impressions or omissions in any form of communication. Question 5. Conditions precedent are usually included in contracts of purchase and sale to protect the buyer. However, since conditions precedent can also be abused by buyers, a seller must be protected when a condition precedent is being included in a contract of purchase and sale. Which of the following additions to the contract of purchase and sale is not a valid method of protecting a seller's interests? Correct answer: B. A clause requiring a property disclosure statement to be filled out can be included in the contract of purchase and sale. Explanation: this option is not a valid method of protecting a seller's interests when a condition precedent is included. While a property disclosure statement, PDS, is commonly requested to provide transparency about the property's condition, it does not directly address or limit the buyer's ability to abuse a condition precedent. The PDS serves as a disclosure tool rather than a mechanism to enforce or constrain the buyer's obligations regarding the removal of conditions precedent. Other options. A. A specific time within which the condition must be removed can be included in the contract of purchase and sale. True. Setting a clear deadline for removing the condition ensures the process is not indefinitely delayed, thus protecting the seller. C. A covenant can be inserted stating that the buyer will use their best efforts to satisfy the specific condition. True. This ensures that the buyer cannot delay or avoid satisfying the condition in bad faith, safeguarding the seller's position. D. A time clause can be included, which gives the seller the right to demand that the buyer remove the condition precedent within 72 hours. True. A time clause, commonly known as a shotgun clause, protects the seller by allowing them to move forward with other offers if the buyer does not act promptly. Key takeaway: while the PDS may be relevant in providing information about the property, it is not a protective measure for the seller against the buyer's use of conditions precedent. Other mechanisms like deadlines, covenants, and time clauses are more effective for this purpose. Question 6. At common law, and unless the agreement stipulates to the contrary, as soon as a contract is signed for the purchase and sale of real property, the risk of loss or damage suffered between the signing of the contract and the completion falls on. Correct answer: A. The buyer. Explanation: at common law, unless the contract specifies otherwise, the risk of loss or damage to the property passes to the buyer immediately upon signing the contract for purchase and sale. This principle is based on the doctrine of equitable conversion, which treats the buyer as the equitable owner of the property, while the seller retains legal title as security for the payment of the purchase price. Other options. B. The seller. Incorrect. The seller retains legal title until completion, but does not bear the risk of loss unless explicitly stated in the contract. C. The seller's insurance company. Incorrect. The seller's insurance may cover damages up until closing, but this is not a common law requirement. The buyer may need to arrange their own insurance upon signing the contract. D. No one. Incorrect. The risk always transfers to one party. In the absence of a contractual agreement, it falls on the buyer. Key takeaway. Buyers should protect themselves by arranging insurance coverage effective from the date of signing the contract to cover any potential risks. Question 7. Larry and Theresa orally agree that Theresa will lease 10 acres of farmland owned by Larry for 5 years. As part of the agreement, Larry agrees to build a barn, which he does at a cost to him of $10,000. Which one of the following statements is true? Correct answer, C. The lease agreement may be enforceable by Larry because he has altered his position by spending $10,000 on a new barn in reliance on the lease. Explanation. Under Section 59 of the Law and Equity Act, agreements concerning land, including leases over 3 years, must be in writing and signed to be enforceable. However, exceptions exist where there is part performance of the agreement. In this case, Larry's construction of the barn at significant expense could qualify as part performance. This action demonstrates reliance on the lease agreement, which a court may consider to prevent unfairness or injustice. Other options. A. The lease agreement is not enforceable by Larry because it is neither in writing nor signed by Theresa, as required by Section 59 of the Law and Equity Act. Incorrect. While the agreement does not meet the formal requirements, part performance, building the barn, could make it enforceable. B. Section 59 of the Law and Equity Act does not apply to lease agreements. Incorrect. Section 59 applies to agreements related to land, including leases exceeding 3 years. D. The lease agreement is void because it is not in writing. Incorrect. The agreement is not void but unenforceable without written evidence unless part performance applies. Question 8. In order to facilitate the exchange of possible resources in a negotiation, it is important. Correct answer, C. To make concessions when necessary. Explanation. In negotiations, making strategic concessions fosters collaboration and builds goodwill between parties. This facilitates resource exchange by showing flexibility and willingness to meet the other side partway. Effective negotiators balance concessions with ensuring their key interests are met. Other options. A. To make repeated concessions in order to get the other negotiator to follow. Incorrect. Repeated concessions without reciprocity might weaken your position and lead to an imbalanced agreement. B. To deliberate issue by issue. Incorrect. While breaking down issues can help, focusing solely on deliberation may overlook opportunities for resource exchange. D. Not to disclose your true interests to the other side. Incorrect. Hiding interests may hinder collaboration and limit the ability to identify mutually beneficial outcomes.
Chapter 11, Contracts for Real Estate. Question 9. Misleading advertising is a criminal offense prohibited by Section 52 of the Competition Act. Which of the following statements concerning this offense is false? Correct answer. C. The standard applicable in determining whether a statement is misleading or not is whether a consumer was actually misled or deceived. Explanation. Under Section 52 of the Competition Act, the focus is on whether a representation is likely to mislead or deceive a reasonable consumer, not necessarily whether an individual consumer was actually misled. It's about the potential effect of the advertisement on the public at large, not just a single person. Key takeaway: the emphasis in Section 52 is on the likelihood of misleading the public, not on whether someone was actually deceived. Misleading advertising can occur even when all statements are technically true. Other options. A. A person or company can be found guilty under Section 52 when the general impression conveyed by an advertisement is misleading, even though every part of their advertisement is true in a literal sense. True. The general impression, even if the individual statements are factually correct, can still be misleading. B. To constitute an offense under this section, the representation must be false or misleading in a material respect. True. The misrepresentation must be significant enough to affect the consumer's decision-making process, i.e., it must be material. D. Someone accused under Section 52 can avoid conviction if they show that they honestly believed that the representation was not false or misleading, and that they exercised due diligence in making sure that was the case. True. If the accused can prove they exercised due diligence and honestly believed their statements were not misleading, this can be a valid defense.
Question 10. A contract of purchase and sale is? The correct answer is a binding contract if properly drafted. Explanation. A contract of purchase and sale is a legally binding agreement between a buyer and a seller to transfer property or goods under specific terms and conditions. To be enforceable, the contract must meet essential elements such as 1. Offer and acceptance. Agreement on the terms of sale. 2. Consideration. Exchange of value, e.g., payment for the property. 3. Legal capacity. Both parties must be legally able to contract. 4. Lawful purpose. The contract must be for a legal transaction. 5. Proper drafting. It must clearly outline the obligations, terms, and conditions. If drafted correctly, a contract of purchase and sale is enforceable in court and binds both parties to perform their obligations. It is not an invitation to treat, which is merely an invitation to negotiate terms, and is far more than just evidence of intent. Question 11. Which one of the following statements is correct? The correct answer is, contracts of purchase and sale can be assigned if the contract includes the standard assignment terms, the assignment does not prejudice the seller, and the contract does not prohibit assignment. Explanation 1. Assignment of contracts. Generally, contracts, including contracts of purchase and sale, are assignable unless the contract prohibits assignment, e.g., a non-assignment clause, and the assignment would prejudice the seller, e.g., harm their rights or expectations under the contract, and the assignment is illegal or against public policy. 2. Standard assignment terms. Many real estate contracts include clauses that explicitly allow assignments. If standard assignment terms are present and the seller's position is not harmed, assignments are permitted. However, this permission can depend on the specific terms of the agreement. 3. Permission is not always required. Unlike what one answer suggests, buyer permission is not a standard requirement for assigning a contract unless the contract itself says so. Thus, contracts of purchase and sale are generally assignable, provided the above conditions are met. If the contract explicitly restricts assignments, then they are not allowed. 12. Which of the following statements about the criminal offense of misleading advertising in Section 52 of the Competition Act is false? The false statement is, a representation to the public includes print and digital representations, but not oral representations. Explanation. This statement is false because oral representations are included under Section 52 of the Competition Act. The Act applies to any form of representation made to the public, including print advertisements, digital representations, oral statements, spoken representations. The Competition Act is broad in scope to ensure that all misleading advertising, regardless of medium, can be prosecuted if it is false or misleading in a material respect and affects consumer decisions. Why the other answers are true. 1. Materially false representations. The offense involves making a representation to the public that is false or misleading in a material respect. Material means it could influence an ordinary consumer's decision. 2. Due diligence defense. A person accused under Section 52 can defend themselves by proving they honestly believe the representation was true and exercise due diligence to verify it. 3. Material respect and consumer decisions. The requirement that a representation be false in a material respect refers to whether the misrepresentation would have a real impact on the decision-making of an ordinary consumer. Thus, the inclusion of oral representations makes the third statement false. Question 13. Where a buyer under a standard contract of purchase and sale refuses to perform, the seller will not have which of the following remedies? The correct answer is the forfeiture of a deposit representing 50% of the purchase price as liquidated damages. Explanation. While a seller does have remedies when a buyer refuses to perform under a standard contract of purchase and sale, the forfeiture of a deposit representing 50% of the purchase price would not be upheld as reasonable liquidated damages in most cases. Deposits and reasonableness. Courts require deposits or liquidated damages to be reasonable and proportionate to the actual damages suffered by the seller. A deposit amounting to 50% of the purchase price is typically viewed as excessive and likely to be considered a penalty rather than a valid liquidated damage clause. Other remedies available to the seller. Specific performance. The seller can seek this remedy in court to compel the buyer to complete the transaction, particularly in real estate where the property is unique. Damages for loss of bargain. If the seller resells the property at a lower price, they can claim the difference as damages. Damages relating to document preparation. The seller may recover costs incurred for preparing necessary documents, provided these costs resulted from the buyer's breach. Why the answer is correct. The courts focus on reasonableness when forfeiting a deposit. Excessive deposits, like 50%, are not enforceable as liquidated damages, as they appear punitive rather than compensatory. Courts typically enforce smaller, reasonable deposits, e.g., 5 to 10% of the purchase price. Therefore, the forfeiture of a 50% deposit is not a valid remedy under a standard contract. 14. Which of the following is not a requirement for an enforceable contract of purchase and sale? The correct answer is deposit. Explanation. A deposit is not a legal requirement for an enforceable contract of purchase and sale. To have a legally binding and enforceable contract, the essential elements are: 1. Names of the parties, the buyer and seller must be clearly identified. 2. Description of the property sold. The property must be described with enough certainty to identify what is being sold. 3. Description of the price and financing. There must be agreement on the price and any financing terms. While a deposit is often common practice in real estate transactions to show the buyer's good faith and commitment, it is not a legal requirement for enforceability. A contract can still be valid and enforceable without a deposit as long as the other essential elements are satisfied. Why deposit is not required? A deposit serves more as an indication of serious intent by the buyer and a form of security for the seller, but it does not form part of the legal essentials for a contract under real estate law. Question 15. An offer to purchase real estate. The correct answer is, must have the words, or nominee, or assignee, if the buyer wishes to assign the contract. Explanation. If a buyer wishes to retain the right to assign the contract to another party, e.g., another buyer or entity, the contract should include specific wording like, or nominee, or assignee following the buyer's name. This ensures the buyer's intention to assign is explicitly stated in the agreement. Here's why the other options are incorrect. 1. Must by default have standard terms relating to contract assignments unless the buyer instructs otherwise. This is not true. Contract terms do not automatically include assignment provisions unless specifically drafted into the agreement. 2. Always provides either party with the option to assign the contract. Contracts are not automatically assignable. Whether assignment is permitted depends on the terms of the specific contract and applicable laws. 3. Cannot be assigned. A contract can often be assigned unless the contract explicitly prohibits assignment. Real estate contracts, however, require proper wording to clarify this intention. Key point. To assign a real estate contract, specific wording such as, or nominee or assignee, must be included to indicate the buyer's right to transfer the contract to another party. Question 16. A seller refuses to sign a subject removal form to strike out a condition precedent from a contract of purchase and sale. Assuming that the condition was made exclusively for the benefit of the buyer, the agreement is. The correct answer is binding. Explanation. When a condition precedent is included in a contract of purchase and sale exclusively for the benefit of the buyer has the right to waive that condition without the seller's consent. If the buyer chooses to waive the condition, the agreement becomes binding and enforceable. The seller refusing to sign the subject removal form does not void the contract, because the condition is intended solely for the buyer's benefit. The buyer can unilaterally decide to remove or waive the condition, ensuring the contract remains valid and enforceable. Keynotes: 1. Conditions precedent for the buyer's benefit. These are meant to protect the buyer, so the seller has no right to enforce or refuse removal. 2. Waiver by the buyer. If the buyer waives the condition, the contract becomes binding. 3. The seller's refusal. The seller cannot prevent the buyer from waiving a condition made solely for the buyer's benefit. Thus, the contract remains binding. Question 17. Velma has just accepted Patricia's written offer to purchase Velma's home, which contains the following clause. This offer is subject to the buyer selling her home at address by December 31st. Which one of the following statements is true? The correct answer is, this requirement may be waived by Patricia on or before December 31st. Explanation: 1. Condition precedent. The clause, subject to the buyer selling her home, is a condition precedent included for Patricia's, the buyer's, benefit. 2. Waiver of condition. When a condition is exclusively for the buyer's benefit, the buyer has the unilateral right to waive it, remove the condition, as long as the condition specifies a time limit. 3. Deadline. The clause explicitly states the date, December 31st. Patricia can waive this condition on or before December 31st, and the contract would remain enforceable. 4. Effective failure. If Patricia does not sell her home by December 31st and does not waive the condition, the contract becomes unenforceable, and any deposit paid could be handled based on the agreement terms. Summary: Patricia has the right to waive the condition, the need to sell her home, on or before December 31st. The seller, Velma, cannot enforce the condition or prevent Patricia from waiving it. Question 18. The Law and Equity Act contains provisions for the unilateral waiver by a party of a condition precedent. Which one of the following is not one of the requirements? The correct answer is, the condition precedent has been satisfied. Explanation: under the Law and Equity Act provisions for the unilateral waiver of a condition precedent. 1. Condition for benefit. The condition precedent must benefit only one party to the contract. 2. Capable of performance. The contract must still be capable of being performed without fulfillment of the condition precedent. 3. Time stipulation. If a time is set for the condition to be fulfilled, the waiver must be made before the time stipulated. The key point is that for a unilateral waiver, the condition precedent does not need to be satisfied. It can be waived by the benefiting party if these criteria are met. Why this is correct: the Law and Equity Act allows unilateral waiver to streamline contracts and prevent one party from using unmet conditions as an excuse to back out. Requiring the condition to have been satisfied would defeat the purpose of allowing unilateral waivers. Question 19. Which of the following are true regarding listing contracts? The correct answer is, the listing contract must be signed by all persons who have an ownership interest in the property being sold. Explanation: 1. Purchaser reliance on listing contract terms. Purchasers generally cannot rely on the terms of a listing contract because the contract is between the seller and the listing brokerage, not the buyer. 2. Signed by all owners. A valid listing contract must be signed by all persons with an ownership interest to ensure that the property can legally be marketed and sold. 3. Terms like approximately or more or less. Even with such terms, the licensee is required to perform due diligence, including conducting a title search, to avoid misrepresentation and protect all parties. This emphasizes the importance of proper execution and adherence to professional standards in listing agreements. Question 20. Which of the following statements concerning listing agreements is true? The correct answer is, all owners listed on title must sign the listing contract. Explanation: 1. Listing agreement and commission entitlement. For the brokerage to be entitled to a commission, the listing agreement typically needs to align with the terms of the sale presented by the buyer. However, Commission entitlement is not solely dependent on whether the offer matches the listing perfectly. Substantially matching offer may suffice in many cases. 2. Reliability of listing terms by buyer. A listing agreement is between the seller and the brokerage. Therefore, a buyer cannot directly rely on the terms of the listing agreement for their purchase decisions. The listing is primarily a contract to allow the brokerage to market the property. 3. Signatures from all owners. To ensure legal validity and the authenticity of the contract, all owners listed on title must sign the listing agreement. This protects the seller and brokerage from legal disputes regarding ownership and authority to sell. 4. Brokerage entitlement without agreement. A listing brokerage will not be entitled to a commission unless it has a signed agreement with the seller prior to listing. Without this formal agreement, the brokerage has no contractual right to receive payment upon a successful sale. Thus, all owners listed on title must sign the listing contract is the correct statement because it ensures that the sellers have properly authorized the listing and can legally proceed with the sale. Question 21. An amendment to a contract of purchase and sale. The correct answer is generally not legally binding on the seller and buyer until finalized in writing and signed by all parties to the original contract. Explanation. 1. Amendment of contract. An amendment to a contract of purchase and sale modifies the original terms. For it to be enforceable, it must be in writing and signed by all parties to the original contract. Until all parties have agreed to the changes and signed, the amendment has no legal standing. This ensures that both the seller and buyer are fully aware of and consent to the changes made to the agreement. 2. Signing parties. The amendment does not need to be signed by the licensee. It must be signed by both the seller and the buyer, as they are the parties to the contract. 3. Terminating contracts. An amendment does not automatically terminate the original contract. Rather, it modifies or adds to the terms of the existing agreement, which remains valid unless otherwise stated. 4. Timing of amendments. An amendment can be made at any time during the contract process, including after the buyer's offer has been accepted by the seller, as long as all parties consent to the changes. Thus, the key is that an amendment is not legally binding until both parties have signed it, ensuring mutual agreement and clarity on the modifications made to the contract. Question 22. Which of the following statements about deposits is false? The false statement is, a binding contract of purchase and sale cannot be formed unless the offer is accompanied by a deposit. Explanation. 1. Formation of a binding contract. A deposit is not a legal requirement for the formation of a binding contract of purchase and sale. A contract becomes binding when there is an offer, acceptance, consideration, and intention to create legal relations. While a deposit is commonly included as part of real estate transactions to demonstrate the buyer's commitment, it is not mandatory for the contract to be valid. 2. Returning deposit checks. If an offer is rejected before banking hours, the deposit check may be returned directly to the offeror by the licensee, as there is no agreement in place. 3. Brokerage holding deposits. Deposits are held in the brokerage's trust account as a stakeholder, meaning the brokerage does not represent only one party and must handle the deposit impartially. 4. Timing of deposit. Licensees are required to deposit the check into the brokerage trust account immediately after the offer is accepted, unless other written instructions are provided. This highlights that while deposits are standard practice, their absence does not invalidate a contract. Question 23. What is the meaning of designated agency in the context of the standard form listing agreement? The correct answer is, the brokerage appoints one or more specific licensees to act as the seller's sole agent. Explanation. Designated agency in the context of a standard form listing agreement refers to the appointment of one or more specific licensees within a brokerage to act as the exclusive agents for the client, in this case, the seller. This means 1. Exclusive representation. The designated licensees owe fiduciary duties solely to the seller. Other licensees within the brokerage are not considered agents for the seller. 2. Brokerage as a neutral party. While the brokerage is involved in the transaction, its role is administrative, ensuring compliance with legal requirements. while the designated agent provides direct representation. 3. No conflict of interest. This arrangement allows other agents within the same brokerage to potentially represent buyers in the same transaction without creating a conflict of interest, as long as confidentiality is maintained. Incorrect options. The licensee cannot act for both the buyer and seller. This describes dual agency, which is different and often restricted or prohibited. The licensee can act for both the buyer and seller. Again, this refers to dual agency, not designated agency. The brokerage and its agents have been designated to act as a team for the buyer. This is incorrect, as designated agency specifically assigns a single agent or team to the seller, not to the buyer. Chapter 11. Contracts for real estate. Question 24. What is a time clause or 72-hour clause? The correct answer is, it refers to the length of time the other party has to remove a condition precedent once the clause is invoked. Explanation. A time clause or 72-hour clause is commonly included in real estate contracts when there is a condition precedent, e.g., the sale of the buyer's home. The clause allows the seller to continue marketing the property after accepting the buyer's conditional offer. If the seller receives another offer, the seller can invoke the time clause, giving the first buyer a specified amount of time, typically 72 hours, but it can vary, to 1. Remove the condition precedent, e.g., waive the condition to sell their home. 2. Back out of the deal, allowing the seller to accept the second offer. This clause protects sellers from being locked into conditional agreements indefinitely and ensures they can still pursue other offers. Chapter 11. Contracts for real estate. Question 25. Which one of the following statements is false? The false statement is, unless a deposit is paid when an offer to purchase is made, there is no binding contract for purchase and sale. Explanation. This statement is false because a binding contract for the purchase and sale of real estate can exist without an immediate deposit. The essential components of a contract, offer, acceptance, consideration, legality, and capacity are sufficient to create a binding agreement. While a deposit is common practice in real estate transactions as part of the consideration, it is not a strict legal requirement for the formation of a binding contract. The other statements are true. Deposits are held by the brokerage as a stakeholder. Uncertified checks must clear before the brokerage can act on the funds. A deposit can be returned only with the written consent of all parties. Question 26. Which one of the following lists accurately describes the correct criteria as agreed upon by negotiation experts for a successful negotiation? The correct answer is efficiency, satisfaction of both parties, minimal wasted resources, preservation of the relationship. Explanation. Negotiation experts emphasize the following criteria for a successful negotiation. 1. Efficiency. Achieving an agreement in a timely and effective manner without unnecessary delays. 2. Satisfaction of both parties. Ensuring that the needs and interests of all parties are addressed, fostering a sense of fairness and mutual benefit. 3. Minimal wasted resources. Optimizing resources, time, money, energy during the negotiation process. 4. Preservation of the relationship. Maintaining a positive and cooperative relationship between the parties, which is crucial for long-term collaboration or repeated interactions. Incorrect options. Zero-sum game. This implies one party's gain is another's loss, contrary to the principles of successful negotiation, which aim for win-win outcomes. Distributive results. This refers to dividing fixed resources, e.g., money, often at the expense of mutual satisfaction and long-term relationships. Question 27. Which one of the following is not required in a contract of purchase and sale? The correct answer is the rate of commission payable. Explanation. A contract of purchase and sale requires 1. The names of the parties involved in the agreement. 2. A description of the property being sold. 3. The purchase price agreed upon by the buyer and seller. However, the rate of commission payable is not required in the contract of purchase and sale itself. Commission rates are typically outlined in the listing agreement between the seller and their real estate brokerage, not in the purchase and sale contract. Question 28. You have recently listed a property for sale at $850,000. An offer of $843,000 was received this morning. At noon, a second offer of $845,000 was received with a subject to financing clause. This evening, an offer of $850,000 was received, also with a subject to financing clause. Which of the offers must be presented? Correct answer: all of the offers. Explanation: under real estate regulations, all offers must be presented to the seller unless the seller has specifically instructed the agent otherwise in writing. This obligation exists regardless of the offer's terms, conditions, or timing. Even if some offers include conditions, for example, subject to financing, or are lower than others, the seller has the right to evaluate all offers and make the final decision. Failing to present any offer without the seller's prior consent could breach the agent's fiduciary duty of full disclosure. Question 29. Which one of the following statements is false regarding successful negotiations? The false statement is: the single best thing that you can do to improve your negotiation effectiveness is to take detailed notes during negotiations. Explanation: while taking notes during negotiations is useful for tracking discussions and agreements, it is not considered the single best way to improve negotiation effectiveness. Instead, developing skills like preparation, understanding interests, effective communication, and practice through real-world application or role-playing are critical for success in negotiations. Negotiation effectiveness is primarily enhanced by 1. Thorough preparation and understanding of both parties' interests. 2. Practicing negotiation techniques regularly to build confidence and skill. 3. Developing active listening and problem-solving abilities. Simply taking detailed notes, while helpful, does not significantly enhance core negotiation skills. Question 30. In a binding contract, a condition precedent can best be described as: correct answer: a condition that must occur before a party is liable to perform their principal obligations under the contract. Explanation: a condition precedent in a contract is an event or state of affairs that must occur or be satisfied before one or more parties are obligated to perform their main contractual duties. If the condition precedent is not met, the affected party is not required to fulfill their obligations under the agreement. For example, in a real estate contract, a condition precedent might be that the buyer obtains financing approval or conducts a satisfactory property inspection before proceeding with the purchase. If these conditions are not met, the contract may become void or unenforceable. The other options do not accurately define a condition precedent. Subject to clauses give some discretion but don't define the nature of a condition precedent comprehensively. A condition discharging obligations refers to a condition subsequent, not a condition precedent. A default-related condition involves remedies for breach, not a condition precedent. Question 31. Where a condition precedent is inserted in a contract of purchase and sale, a licensee might also include a time clause. Which of the following definitions accurately describes such a clause? Answer: the clause permits the seller to require the removal of the condition precedent within a specified time, if a better offer is received. Explanation: a time clause, sometimes referred to as a 72-hour clause, is typically included in a real estate contract to protect the seller when a condition precedent benefits the buyer, e.g., the buyer selling their home first. If the seller receives a better offer, the time clause allows the seller to issue a notice requiring the buyer to either remove the condition precedent or let the agreement terminate within a specific period, commonly 72 hours. This type of clause ensures that the seller is not indefinitely bound by the buyer's condition while still giving the buyer a fair opportunity to proceed with the transaction. The other options do not fully or accurately describe a time clause. Requiring the removal of a condition precedent within a reasonable time is too vague. Stating a specific date for removal is typically done in the condition precedent itself, not in the time clause. Chapter 11. Contracts for real estate. Question 32. When completing a listing contract, a licensee should: correct answer: independently check information with the appropriate authority where possible. Explanation: when completing a listing contract, a licensee has a duty to ensure the accuracy of the information included. While sellers often provide information about the property, such as dimensions, legal descriptions, or zoning details, It is the responsibility of the licensee to independently verify these details where possible, such as by consulting official records or authorities, e.g., land titles offices, municipal records. This approach minimizes the risk of inaccuracies that could lead to disputes or legal issues. Relying solely on the seller's information, even if the seller claims to have verified it, is insufficient and can expose the licensee to liability if errors arise. The other options are incorrect because blindly relying on seller-provided information is negligent. Advising buyers that the seller's information is unreliable does not absolve the licensee of their duty to verify facts. Question 33. Where a buyer makes an offer to purchase land and does not pay a deposit. Correct answer. A contract will be formed on acceptance without existence of a deposit. Explanation. Under contract law principles, a deposit is not a mandatory requirement to form a binding contract of purchase and sale. A deposit serves as a show of good faith and security for the transaction, but is not essential for the formation of the agreement itself. The key elements of a valid contract include an offer, acceptance, consideration, and mutual intent to be bound. In this context, the consideration could be the promise to pay the purchase price, even if no deposit is made. The other options are incorrect because a deposit is not a legal requirement for contract formation. A licensee paying $1 into a trust account does not replace the need for proper agreement terms between the buyer and seller. An offer without a deposit is still an offer and not merely an invitation to treat. Question 34. A seller refuses to acknowledge the waiver of a condition precedent from a contract of purchase and sale. Assuming that the condition was made exclusively for the benefit of the buyer and the waiver was made prior to the expiry of the condition precedent, the agreement is: answer, binding. Explanation. A condition precedent included exclusively for the benefit of the buyer can be unilaterally waived by the buyer, provided the waiver occurs before the stipulated expiry date of the condition precedent. This waiver makes the contract binding and enforceable against both parties, regardless of whether the seller acknowledges the waiver. Under the Law and Equity Act, unilateral waiver is valid as long as 1. The condition precedent is exclusively for the benefit of the waiving party, the buyer. 2. The waiver is made before the condition's expiry. 3. The contract remains capable of being performed without fulfillment of the waived condition. Since the condition was waived correctly and on time, the seller's refusal to acknowledge it does not affect the binding nature of the agreement. Chapter 11. Contracts for Real Estate. Question 35. Which of the following statements is true? Correct answer. The court has the power to enforce an oral contract respecting a disposition of land, if necessary to avoid an inequitable or unfair result where the party relying on the contract has substantially altered their position. Explanation. Under Section 59 of the Law and Equity Act, a contract for the disposition of land must generally be in writing to be enforceable. However, equitable principles, such as part performance, may allow a court to enforce an oral contract if one party has significantly altered their position in reliance on the agreement, and failing to enforce it would result in unfairness. For example, if a buyer has made substantial improvements to the land or paid part of the purchase price in reliance on the oral agreement, the court may enforce the contract to avoid injustice. This exception exists to balance the strict formalities of Section 59 with the need to address equitable considerations in specific circumstances. Question 36. Which of the following scenarios is least likely to offend Section 52 or Section 74.01 of the Competition Act, i.e., the criminal and civil offenses of misleading advertising? Correct answer. A licensee advertises a Yaletown condo as 1,000 square feet. The condo is only 998 square feet. Explanation. This scenario is least likely to offend Section 52, criminal, or Section 74.01, civil of the Competition Act, as the difference in size, 2 square feet, is minor and unlikely to be materially misleading. The test under both provisions of the Act requires that the misrepresentation be false or misleading in a material respect, meaning it must have a significant impact on a consumer's decision-making. A minor discrepancy of this nature would typically not meet this threshold. By contrast, knowingly misrepresenting the number of bedrooms, first scenario, or the price of listings, third scenario, involves substantial and material false statements that could influence a buyer's decision, violating the act. Failing to verify the kitchen renovations, second scenario, shows negligence, and if the representation is materially false, it could breach Section 74.01. However, it is less severe than knowingly providing false information. Question 37. Which of the following accurately summarizes the requirement of writing contained in Section 59 of the Law and Equity Act? Correct answer. None of the above three statements accurately summarizes the requirement of writing. Explanation. Section 59 of the Law and Equity Act requires that certain contracts respecting land or interests in land must be evidenced in writing and signed by the party to be charged or their agent to be enforceable. However, none of the provided statements correctly reflect the provision. 1. A contract respecting land must be in writing or it is void. This is incorrect. While writing is required for enforceability under Section 59, the absence of writing does not render the contract void. It is unenforceable unless an exception applies, such as part performance. 2. A contract respecting land can never be enforced against a party who has not signed it. This is overly broad. For example, oral contracts may sometimes be enforceable under doctrines like part performance, provided there is evidence of significant actions that demonstrate reliance on the contract. 3. A contract for the sale of land must be contained in one written document. This is incorrect. The required terms can be pieced together from multiple documents, provided they collectively satisfy the requirements of Section 59. Conclusion. The correct interpretation of Section 59 allows for flexibility in certain situations, such as part performance or multiple writings evidencing the agreement, which none of the options fully capture.